May it please the court, I'm Richard E. Brodsky, and with me is Armando Montalvo.
Mr. Brodsky, you admitted that you were in default, your client.
Yes.
What were you in default of?
That's not in the record.
What?
That is not in the record. It's not in the record through admissible evidence.
I'm sorry?
It is not in the record through admissible evidence. If you're asking how much, that's not in the record through admissible evidence.
No, I'm asking what you were in default of.
Payment on the note.
The note that was introduced and the mortgage that was introduced into evidence, you signed that, didn't you?
You're not liable on the mortgage, you're liable on the note.
Did you sign it?
There's no question, Your Honor, that my client was in default on the note.
And how long has your client lived on the property without paying anything?
Since 2008.
I'll accept that.
And the last question, which I've heard from several judges, did anybody put a gun to his head?
That isn't, none of those questions.
The issue is standing. You're not disputing that HSBC came in and was the holder of the original note and mortgage. You're not disputing that at the time of trial they produced it. Your entire argument is the standing argument, correct?
Well, it's not the entire argument, but it is the core of the argument. And, Your Honor, Judge Schwartz, that's like saying the robber was convicted, but let's leave out the technicality that the government didn't prove it through admissible evidence. We all know the robber was guilty. That's not the law, and I wouldn't accept that as a law in a civil case either.
All right, so let's talk about the standing issue, because this is a very confusing area at best, and so I tried to make sense of some of the documents to figure out really what was happening in this case, because from your brief you were accusing either Wells Fargo Bank or HSBC Bank as producing a fraudulent document or something funny going on in terms of the assignment of the mortgage.
By the way, I forgot to reserve 3 minutes.
Thank you. So let's talk about the standing.
Let's just talk about the facts.
Let me ask you some questions, specific questions about servicing and pooling agreements,
yes.
And specifically this one.
Which is not in the record.
It is in the record. I read it.
Well, that's because the other
This
side moved.
This is it, and it's very lengthy.
The other side moved to have it supplement the record.
But it's in the record.
It was granted, though. I mean,
it's in the record.
All right. I did not see the order granting a motion. I'm sorry.
The servicing and pooling agreement you have to look at in conjunction with the sale from Wells Fargo Bank to Wells Fargo
Asset Securities Corporation.
I'll call them Wells Fargo Securities.
Good.
If you look, because they were both signed at the same day, they both occur at the same time. Correct?
Yes.
And from my reading of it, and I want you to correct me if I'm wrong, is that when Wells Fargo Bank sold all of these notes and mortgages to Wells Fargo Servicing, they also at the same time made HSBC the trustee and required that all of the documents concerning the notes and mortgages all go to HSBC as the trustee.
No, that's not what the agreement says.
Well, let's look at
it. Or the custodian. Or the custodian.
Show me where it says custodian here. Look at the mortgage loan purchase agreement. Show me where it says custodian.
While you're looking at that, maybe you can answer this question. Did you raise standing as an affirmative defense in the case? Okay.
Did you say anything else besides that?
Excuse me?
Did you say that anything besides the plaintiff lacks standing?
Not material to this appeal. The issue, Your Honor, is simply not whether let's call my client a deadbeat.
That's not the issue.
That isn't the issue.
The issue is, did HSBC
have standing? How do they get standing?
They get standing as the trustee, and if you look at the servicing and pooling agreement, it gives HSBC the right and the sole right to execute on these notes as the holder of the notes and the mortgages.
If Your Honor, please let me get my page out. I want to refer you to,
let's say that, go ahead.
I would like to refer you to section 2.01, which says, Wells Fargo Asset Securities Corporation directs Wells Fargo Bank NA as seller.
Where are you reading this?
Section 2.01.
Of the pooling and servicing agreement?
Yes.
Okay.
To
So
deliver the
what
loan
subsection? What subsection?
2.01.
0.201 what?
I don't,
Blank it.
Mr. Honor, please, I'm sorry, I don't have that document in front of me. And if counsel would be willing to let me have their copy, I apologize, I forgot to bring it with me, and
Because if you look at
blame myself.
7.02, it says, the trustee, in addition to the rights specified in section 7.01, shall have the right in its own name as trustee of the express trust to take all actions, now or hereafter existing at law, in equity or by statute, to enforce its rights and remedies, and to protect the interests and enforce the rights and remedies of the certificate holders, including the institution and prosecution of all judicial, administrative, and other proceedings in the filing of proofs of claim and debt in connection therewith.
But only if it complies with the law. Who can enforce a note?
A holder.
A holder. What is a holder? One in possession of a note payable to bearer, or a note payable to the person in possession. This was a bearer note. So the question is,
But
did they prove?
HSBC, as the trustee from the time that this pooling and servicing agreement was entered into, became the trustee of the notes and the mortgages, and it specifies in the sale document, the purchase sale agreement, that all of the documents are to specifically go to HSBC.
No, that's not what it says. It
You
says
don't have to
the
be
custodian
a
or the
holder.
trustee. It says
The custodian is the holder, isn't it?
It does.
the custodian is a holder, and now let's get exactly to it. The custodian is a holder. Now, the custodian, there is no admissible evidence that the custodian delivered the note in bearer form to the trustee or its agent, the counsel, before the lawsuit was filed. There is no admissible evidence.
Just a minute. Was the note and mortgage attached to the complaint?
No. They filed a lost note claim.
But what they did submit was the filing, the record filing of the mortgage, which predated
No,
the
not
filing
the
of
mortgage.
The
The
mortgage.
assignment, no.
The assignment of the mortgage.
But the assignment was made by Wells Fargo Bank NA per that document. Wells Fargo Bank NA had already sold it to Wells Fargo Asset Securities Corporation
what happens if
in 2007.
What happens if you win this case?
My man, sadly, gets a condo.
Here's what it
But
says.
that isn't the test.
Here's what it says in the mortgage
You mean
loan
to tell me
purchase agreement.
that the actual holder, if there is a different one, or the same holder, or the same plaintiff, cannot now bring the case?
That is a question of res judicata and or collateral estoppel, and that's an issue for another day.
Let's look at
That
the mortgage.
isn't the issue for today.
It's not an issue for another day, because it's got to be dismissed for lack of standing, which is not res judicata. So what it means is that you file it the next day. And as a matter of fact, even if you're right on the law, which you're not, even if you're right, the remedy should be to have a stay pending the acquisition of the note and mortgage if there was anything different until the next day.
If Your Honor, please, I am right on the law. There's no question that there was no competent, admissible evidence that the trustee had the note in its possession before it filed the lawsuit.
Let's look at the mortgage loan purchase agreement. The company is Wells Fargo Asset Securities Corporation, the purchaser of all of these notes and mortgages. It says the company hereby directs the seller, and the seller hereby agrees to deliver to the trustee or custodian on behalf of the trustee all documents, all documents instruments and agreements required to be delivered by the company to the trustee under the pooling and servicing agreement. And then when you go to the pooling and servicing agreement, it says that the trustee will have the right to, upon default, to file any action in its own name.
But it can't do that if it doesn't have possession of the note.
The complaint, in the complaint, HSBC specifically says it had possession of both the note and the mortgage.
God bless. They allege it.
Okay.
But they have to prove
They
it.
then bring in a witness who says that she reviewed the documents, the business records of the company, and that the company did have possession of the note and the mortgage prior to filing this complaint.
It's true that that's what happened. Is that competent, is that evidence? That's the person who testified she had no personal knowledge.
Was there a...
Sorry, Your Honor.
Go ahead.
I'm sorry, Your Honor.
I'm sorry, sir. Go right ahead.
It was admitted as a business record. If she reviewed business records, doesn't the case law say that she can testify from reviewing business records that were created under the business record exception? They were created by someone who had the right to do that, and that they were kept in the normal course of business and all of that.
But for the fact that they weren't offered. What was offered was the amount due. It wasn't qualified as a business record, but there was no document offered showing...
What was the objection?
To...
This testimony.
The testimony was lack of personal knowledge. Which is...
That's not an objection.
I'm sorry?
Lack of personal knowledge, quote unquote, is not an objection, or not a good objection.
Of course it is. It's because personal knowledge is required in order to make testimony admissible. Now,
how would you, let's say that you were representing the other side, how would you prove that your client should have paid this mortgage and note?
How would I approve standing?
Yes.
I would have had that witness, and I would have brought in the records that showed when the delivery to HSBC occurred, and I would have offered them in evidence. They would have gone in probably as business records. Let's assume that they went in as business records. And that didn't occur. That didn't occur. That's our case.
Okay.
They brought in a witness who said, I heard it through the grapevine.
No, that's not what the witness said. The witness said, I reviewed the business records. She then...
How do we know that? Did we have the records?
Because you vigorously cross-examined her, so that her testimony is revealed to be a tissue of lies.
What would have been the difference between her saying, I heard at the water cooler that this note was delivered, and I saw some documents that I didn't even bring to the courtroom? Because that's
inadmissible hearsay. However, if you testify from business records, that's not inadmissible hearsay, and it becomes
business records because they were not in evidence. That's the point.
Did the trial court admit them into evidence?
Please?
Did the trial court admit them into evidence?
There were no documents in the courtroom that established the date of delivery. That is a key point. The only documents offered, which we contend were not qualified as business records, was on the amount due. There was no document in the courtroom that dealt with the question of
Your argument is that even if what she reviewed was a business record, because they weren't produced at trial, then, or for the trial. Since they weren't produced at trial, then that is...
And admitted in evidence.
Right. Well, obviously, if it's introduced at trial, it's admitted into evidence. You're saying that someone cannot testify from a business record unless the records are specifically introduced.
Correct.
Okay. And what do you need the testimony for?
What case supports that position?
I don't need a case for that.
Okay.
Okay, because you said so is enough.
May I supplement the record with a letter giving you the case?
You can supplement the record with a case that supports that position, yes.
Yes, thank you. I will do it this afternoon.
Okay. Thank you.
Do I still have some time?
Definitely not. You're way over your time. So I'll give you some time for rebuttal.
Please, sir.
May it please the Court, Alan Rosenthal and Tika Cunningham of Carlton Fields on behalf of HSBC Bank as trustee.
May a witness who testifies from review of business records, let's say business records are qualified as business records, and comes in under the exception, may a witness testify regarding business records that they have reviewed without introducing those records at trial?
Yes, under the progressive case cited in our brief.
Thank you.
This case, and the Court is well familiar with the glut of foreclosure cases. This one is relatively simple. The loan was originated by Wells Fargo Bank. Wells Fargo serviced it from the date of origination up through now. It was assigned to a trust about a year after origination. The original note never left Wells Fargo. The mortgage purchase agreement and the pooling and service agreement all accurately reflect the transfer of the loan, and the pooling and servicing agreement and the mortgage loan purchase agreement direct Wells Fargo Bank NA to transfer the note and mortgage to the trust, which they did.
Let me ask you this. Does the pooling and servicing agreement require both the mortgage and the note, the mortgages and the notes to be transferred to the trustee, or only the notes?
All documents in connection with the loan. The loan documents are then owned by the trust through the securitization process. Now, one of the things that counsel raises is that transfer was done improperly. As this Court decided last Wednesday, Mr. Blanco lacks standing to challenge the efficacy of the process by which the pooling and servicing agreement acquired these loans in the Castillo case. Ms. Brust, the Vice President of Loan Documentation, not a specialist a la Glarum,
She got that information at the water cooler.
You sorry, sir?
She got that information at the water cooler.
She testified very clearly. This is her job. She reviewed the records. She compared the numbers to the proposed final judgment. This was not a summary judgment hearing where the Court lacked the ability to determine the credibility of the witness.
Well, the amounts due and owing, those records, the computer-generated records, were introduced.
Yes.
So we're only talking about the other documents that she reviewed as to the date that the assignment was made, or that they obtained possession of the note and the mortgage.
The note and mortgage were admitted into evidence without objection. The note and mortgage, as conceded by counsel, endorsed in blank, became a bearer instrument. The assignment of mortgage that was executed from Wells Fargo Bank to HSBC was executed more than a week before the original complaint was filed. The entire origination and servicing file maintained by Wells Fargo was produced in discovery many, many moons ago. Mr. Blanco didn't come to the trial. Nothing was introduced. So 4 years after default, in this case, we are standing here today on what we submit are meritless arguments.
And therefore, you wish to be affirmed.
Yes, sir. And I want to say one other thing, because I want to take the opportunity to ask this Court, along with the sister courts of this state, to help the court system move these cases, not when there is fraud, not where there is wrongdoing, not where there is negligence by a bank or a lawyer or anybody else. But we have been pending for more than 2 years on defenses that were stricken, on counterclaims that were dismissed, that were pending for far too long. Part of the answer to this crisis is direction from the appellate courts of this state to the members of the Florida Bar.
Well, Judge Wells said recently, in a case in which it was reversed, that it's time to, even though it was reversed, when it comes back the next time, sanctions may well be in order. This is the next time, the first time.
We request that the judgment be affirmed. Thank you, Your Honor.
Thank you.
In answer to Your Honor's question, I apologize for having a brain lock. At pages 4, 5, 6, and 7 of my reply brief, I specifically discussed the cases that address Your Honor's question. And I apologize for not thinking fast enough at my advanced age to inform the court. Thompson versus State specifically says that the business records exception to the hearsay rule does not authorize hearsay testimony concerning the contents of business records that have not been admitted into evidence. Also, Boland, and I list all the cases at pages 5 and 6. There is no question under the law that documents not in evidence cannot be testified to as to the truth and content.
What documents are you referring to?
Here, I would be referring to the documents that this witness said she read, which she says testified showed when the note was delivered to the trustee, which establishes standing. If we don't care about standing, then of course we affirm because we admitted we were in default. Then let's do away with the section that deals with standing. Let's do away with the rule of evidence that says you have to have
let's destroy the entire fabric of Anglo-American jurisprudence.
Oh, I'm not asking for that. I'm asking merely that some very elementary rules be adhered to.
Mr. Brodsky, was this individual on the witness list?
I have to ask counsel. The evidence I have, which is Mr. Montalvo's telling me, is that apparently he was on the list.
Did you depose her? Did you depose her?
Oh, was their witness on the list?
Mr. Ross.
I thought you meant the plaintiff. I mean the defendant, excuse me. That's a very the answer is yes, just before the trial. Just like minutes before the trial she was deposed. I'm not sure what the relevance of that is, but that's the answer to your question.
Well, because that's normally in the course, since you're talking about the rules of procedure, normally that's why we don't have trial by ambush. You have discovery, you can depose individuals, and then you go to trial, and you are able to ascertain and prepare your defenses. Your defense is there's no standing, and you could have deposed her and ascertained the answers to those questions in the deposition, correct?
If Your Honor, the answer is yes, but, and the but is that the record, which wasn't thought relevant to this appeal, is one of many obfuscations by the plaintiff as to obtaining discovery and producing discovery, so that it's not as easy as Your Honor says. But let's suppose... Is there any issue on appeal as to discovery violation? He had not raised that on appeal. But in answer to, I was trying to address the question. I want to summarize by saying...
Counsel, you've gone way over your time, so make it short.
1 minute.
You want reversal, is that?
I want reversal. I want reversal because of the failure of the trustee of the plaintiff to adhere to some easily remedied defects in their proof.
If they're easily...
Sorry, Your Honor?
You may proceed. Go ahead.
Sir?
You may proceed.
Okay. Easily remedied. Wouldn't cause the banking system to fall flat on its face. If the banking system... In other words, you haven't been in the slightest bit harmed by any alleged derelictions. Is that correct? I've been harmed because I'm going to lose my apartment. But that's a result in search of a rationale. The fact that if you disregard... You lose your apartment or your home because you haven't paid the mortgage. That is an unfortunate, necessary product of the rule of law. If the rule of law is going to apply, and institutions, no matter how high and mighty, are not going to be held to rules that the first-year law student learns and the first-year lawyer learns. Yeah, that is very offensive, Mr. Brodsky. You know, it is bad enough
And I think it's very bad to have this kind of position in this kind of case. But to be self-righteous about it and to make the rule of law dependent upon it is very offensive.
Well, I don't mean to be offensive.
I know you don't mean to be.
I apologize profusely to the court for appearing to be offensive. I have a client's interest to protect, and the client's interests are protected by application of the rule of law evenly. And in this case, they could have so easily proved standing by having this witness bring the documents that allegedly
So you say that in fact there is standing.
I don't know whether it's standing, because I don't know whether or not, and there's no record evidence to prove that the trustee had to know when it sued. That's the question. All this other stuff is irrelevant.
Thank you, Mr.
Thank you so much, and I'm sorry.